Hi everyone. Legal studies plays a very important role in CUET examination, especially when you are aiming for BA LLB from different colleges under CUET. You need to keep legal studies as a subject. So it's very important for us to revise and go through each and every concepts of legal studies. In today's lesson, I would be talking about judiciary. Judiciary plays a very important role, not only from the perspective of legal studies but also from the perspective of general knowledge. And when you are aiming for CUET, you can expect at least 10 to 20% of questions from judiciary. So in this lesson, I would be covering some part of judiciary because it's a very important topic. So I'll cover it in two aspects. So in the first aspect, we'll go ahead with the basic structure of judiciary. So this is all about the first chapter where we are talking about structure and hierarchy of the courts. Then we are talking about the salient features of Indian judiciary. Then there are certain, appointment which is done under the constitution, for example, Attorney General of India and the law officers in India. So we'll also cover these aspects. Okay, so first of all, we need to study structure and hierarchy of courts in India. So when we talk about structure and hierarchy of courts in India, we have adopted a federal system of government. And here, law enacting power is between the center and the state. So here, the law making power is given to center and state, but there should be a body who is going to keep a check and balance on these laws. So we have Supreme Court as the apex court of the country. That means this is the highest law authority, you can say, in our country. This is the topmost court in our country, and this is one court which not only works for the enactment of, or you can say enforcement of law, but this court also looks after the rights of people. This is something which is there to create a check and balance between the legislature and the executive, which is making law, and judiciary, which is creating or keeping a tab on the law so that it does not violate your rights. Then we have Supreme Court is at the apex level. Below this we have High Court. So each and every state is not having a high court. We have 25 high courts in India. Some of these states are run by a single high court. For example, when we talk about Haryana and Punjab, so we have Chandigarh High Court, which looks after both these states. Then below this high court, we have district court and we have session court. District court basically deals with the matter which is related to civil aspect, and session court deals with the matter which is related to criminal aspect. Below this also there are certain courts. For example, we have civil judge court, we have municipal courts. Apart from this, you can also have different kinds of special type of court which has been created for special matters. For example, you may have a family court also to look after the issues which is related to family. And then we also have specialized tribunals to adjudicate sector specific claims. For example, you have tax tribunal. So this is the structure and hierarchy of courts, which we will discuss in subsequent slides in detail. When we talk about Supreme Court of India, so as discussed, Supreme Court is the apex court of the country. It is the custodian, it is the guardian of our constitution, and this court has been vested with the power to look after our rights, to maintain a balance between the law and rights of the people. Supreme Court of India came into being on 28 January 1950. So after independence, we went ahead with Supreme Court of India. Before this, we were having Federal Court of India and we were having Privy Council. So Supreme Court of India replaced both these Federal Court of India and the Privy Council. In 1950, Supreme Court came up with a Chief Justice and 7 judges, but at present the total strength of Supreme Court is 34 judges, which includes the Chief Justice of India. Now this is a very interesting fact when we talk about the strength of judges of Supreme Court. So recently only when 2 of the judges took oath for Supreme Court, the strength was full. So it was always a kind of debate and discussion that why we don't have a full strength in Supreme Court. So in the month of May itself, the strength went to 34 after 2 of the judges took the oath. So now we are having a full bench of 34 judges in Supreme Court. Okay, also when we talk about the strength of judges, also when we talk about the, Supreme Court coming into picture, when you take into consideration current affairs, it is very important to keep an eye on all the information on which Supreme Court is working, or on which there's a kind of, you can also say there's a kind of tussle between the government and judiciary with respect to appointment of judges, or for that matter if Supreme Court is coming up with an important judgment. For example, when we talk about sedition, so sedition is in news, and it's also, there's a ongoing proceeding happening in Supreme Court, where Supreme Court has also asked the government why we shall continue with the sedition as a law. So if you talk about judiciary per se, if you talk about Supreme Court per se, and from CUET perspective, it's very important to keep an eye on all the current affairs, because this may come under legal studies also. They can ask questions based on the static aspect like appointment of judges and all. They can also ask questions with respect to current affairs, which can be your part of section 3 of legal studies, which is having general knowledge as a topic. And obviously judiciary, being the third important organ of the government, can come under the section general knowledge also. So it's very important for us to keep an eye on all these information. Then when we talk about the second in hierarchy, so obviously we have high courts, and as discussed, we are having right now 25 high courts at the state and union territory level. High court has a jurisdiction over a state, a union territory, or a group of state, as I have given the example of Punjab and Haryana High Court, and union territories. When we talk about the high court, so Madras High Court in Chennai, Bombay High Court in Mumbai, Calcutta High Court in Kolkata, and Allahabad High Court in Prayagraj, now it's Prayagraj, are the first 4 high courts in India. Also guys, again when we are talking about Supreme Court, again when we are talking about High Court, here again you need to keep an eye on the judgment which is given by High Court, which plays a very important role. For example, generally we need to focus on the judgment given by Supreme Court, because that is something which impacts the entire country, so we need to remember that. But at some extent we also need to keep an eye on the judgment which has been given by High Court, because it also plays a very important role. To explain this through example, the best example of this is, you must have heard last year we had a petition in Supreme Court where the question was with respect to right to access to internet, whether it is a fundamental right or not. It was with respect to Jammu and Kashmir, where all kind of curfew was there was no internet connection and everything. So the question was with respect to right to access to internet, whether this is a fundamental right or not. So the Supreme Court stated that this is a fundamental right and everybody has the right to access to internet. So here the judgment of Supreme Court, although is very important, we also need to keep, or we also need to go back and check that for the first time Kerala High Court stated that right to access to internet is a fundamental right. So again here the importance of High Court, their judgment plays a very important role, because from here we came to this where Supreme Court decided right to access to internet. So all these information you have to keep in mind from GK perspective also, and from legal studies perspective as well, because they may ask questions based on landmark judgment of that particular maybe year, maybe landmark judgment of till now whatever has happened in Indian history. For example, when we talk about Keshwanand Bharti judgment, so it's obviously one of the landmark judgment and we need to keep an eye on this judgment, because here again in future we would be talking about basic structure of the constitution. So there Keshwanand Bharti judgment plays a very important role. Then as discussed that below High Court we have district and subordinate courts. When we talk about High Court, so they function, District Court, they function below the High Court. This we have already discussed. State is divided into judicial district presided over by a district and session judge, district judge when presiding over a civil case, and session judge when presiding over a criminal case. So as we have just discussed that Supreme Court is at top level, then below this is High Court, then below this is two kind of court, one is district court and the second one is session court. District court deals with the civil matter. When we talk about civil matter, it is basically dispute between, you can say property dispute is there, taxation dispute is there, or let's say there's a kind of family dispute also. So all these will fall in under the category of civil dispute. Session dispute is basically criminal in nature. So in civil dispute, it's basically two individuals who are involved. If there's a cases with respect to, you know, contract also, so this will fall within the category of civil jurisdiction. When we talk about criminal one, so criminal is basically whatever is covered under, you know, IPC. Like if there's a case with respect to murder, if there's a case with respect to theft, so there the session court is having jurisdiction. Session court will look after that matter. So it is, the hierarchy is like Supreme Court, High Court, District and Session, and below this we can have civil judge court, municipal courts and all. Okay, so this is what is being stated, that after below this we have metropolitan session judge when presiding over a district court in a city which is designated as metropolitan area. So there you don't call it as a session court, you don't call it as a district court, you call it as a metropolitan session court. Then district judge is the highest judicial authority below a high court judge. Also, when we give jurisdiction to a court, like we just discussed that, you know, district court looks after civil matters, session court looks after criminal matters. There are other way of also deciding the jurisdiction of a court. For example, there can be, you know, jurisdiction based on pecuniary value, that is the monetary value, that this particular court will deal with only this much of issues or this much. If the value of the case is this much, then only they'll decide it. The best way to understand this again is to go ahead with the consumer forum. So you all must be knowing that consumer forum is again divided into three parts. One is district, the second is state, and the third one is national level. So again here it is being, you know, the division is done basing on monetary value, that if a case is having, you know, issues below 1 CR, so that will go to district court. If it's having a case between till 1 CR, so this will be decided by state. If the, you know, claim is above 1 crore, so that will be decided by national court. So pecuniary value is also one of the way of deciding the jurisdiction of the court. Okay, then it also states that district court also holds appellate jurisdiction and supervision over all subordinate court. So whenever the court is being, you know, the matter is being decided by junior civil judge, senior civil judge, or for that matter municipal court, so from there you can go in appeal to district court. Subordinate courts on criminal side include second class judicial magistrate, first class judicial magistrate. Similarly on civil side it includes junior civil judge, principal junior civil judge and all. So here you can, after, you know, if you're not satisfied with the judgment of junior civil judge court or principal civil judge court, you can move and appeal to district court. Similarly, if you're not satisfied with the judgment of second class judicial magistrate, first class judicial magistrate, so you can go in appeal to session court. And then we have municipal court, which is handling matters of civil nature and functions below the subordinate court. So these are the hierarchy. So basically, you know, we need not to keep in mind all the courts, like what are kinds of court which is at the lower level or lower judiciary level. We just need to remember that, okay, below district court also, below session court also, there are certain categories of court. And from there the matter goes in appeal to district court. From district court you can go in appeal to high court, and if you're not satisfied with the judgment of high court, you can move to the Supreme Court, because that is again the apex court, so that they are having the final authority to decide a particular case. Then tribunal, as we had discussed, that tribunal is also a kind of, you can say, it's not called as a judicial body, it is considered as a quasi judicial body or semi or quasi judicial bodies. Why? Because here the administrative officers or judges without a legal background can also be appointed. So for example, if there's a tax tribunal, so there can be a person who can be appointed as a judge who is having, you know, all the knowledge of taxation, or for that matter who is having the knowledge of, let's say, how GST works and all. So if the person is, you know, having expertise, he can be appointed as a judge to look after the taxation matter. It works as a judicial under, you know, it works as a judicial body. It's having all the judicial capacity. They can hear relevant legal matters and settle claim between the parties. There are also tribunals which is created for certain specific dispute. For example, if there's a dispute with respect to sharing of waters between states, so there also a tribunal can be constructed, or tribunal can be created to look after the matter. It increases the efficiency in resolving dispute and reducing the burden on court. So as we know that from higher level to lower judiciary, there are numbers of cases, or you can say lakhs of cases, which is pending at different level. So in order to reduce the burden of different courts, we have created tribunal which will which solves the matter quickly within a given time period. And also it is a kind of like, for tax matter, now I need not to go to Supreme Court, I need not to go to High Court, I can directly go to the tribunal which is dealing with the taxation matter, or for that matter insolvency. So I can directly go to the court tribunal which is dealing with insolvency thing. So here the burden of court is getting reduced to some extent. Then it is also explaining the examples of the tribunals which we are having. For example, we have CAT, Central Administrative Tribunal, for resolving the grievances and dispute of central government employees. So suppose there is some dispute with respect to appointment of employees, there is some dispute with respect to removal of employees, so there you can move to CAT. State Administrative Tribunal for state government employees. So it's not like ना कि central government के employees में problem हो रही है, state government में नहीं हो रही है, ऐसा तो नहीं है. So we need to have a specific tribunal which will look after the state administrative or state issues. So we have SAT for that. We have Telecom Dispute Settlement Appellate Tribunal for resolving dispute in the telecom sectors in India. So वो 4G, 3G and बाकी जो issues होते हैं, Airtel and let's say वोडाफोन के बीच में कुछ इश्यू है, या फॉर दैट मैटर दे आर टू टेलीकॉम कंपनीज हु आर फाइटिंग विद ईच अदर, सो दे कैन मूव टू टेलीकॉम डिस्प्यूट सेटलमेंट appellate tribunal. And then we have National Green Tribunal for disputes involving environmental issues. We are very much concerned with pollution, we are very much concerned with protection of environment, so they need to have a specific tribunal which will deal with the matters related to environmental issues. For example, in 2020 you must have heard that there was a gas leak case in Visakhapatnam. So that case went to NGT because it was related to environmental issues, so the National Green Tribunal decided that matter. So for specific matter, tribunal can be created, and that tribunals helps in faster delivery of judgment. That tribunals helps in reducing the burden of the court also. And then when we talk about the salient features of Indian judiciary, so India as a common law jurisdiction, we have borrowed many of the features from UK. So from there also we have borrowed this common law jurisdiction feature, which is like we are not following the civil law thing, but we are going ahead with British tradition of common law. Here the idea of common law features is that if let's say Supreme Court passed a judgment, so that judgment can take a shape of law, and that law would be binding on each and every individual. That law would be binding on the government as well. For example, when Supreme Court puts up a ban on sale and purchase of crackers during Diwali, so that is a kind of law which has been made by Supreme Court and which is binding on people. So here we can say that it is a common law system where judiciary has been given the power also to frame laws, which is not there in civil laws. And also generally when we say about law making power, it's obviously with legislature and executive, but under common law system, Supreme Court, or for that matter whichever is the court there, to some extent they do have a power to make laws. So the decision, orders and judgment developed by the judges in India help in creation and development of laws and legal principles. For example, again the same thing with respect to sedition, that Supreme Court is asking government ki why we should not get away with this law. Tell us a reason. If you won't tell us a reason, we'll tell us whether we shall keep section 124A of IPC or not, or whether we shall get rid of this. So here if Supreme Court gives a judgment, then obviously government would be bound to follow that judgment. Government will have to frame laws or will have to get away with this section basing on whatever Supreme Court decides. Similarly, when you talk about, let's say, when Supreme Court declared triple talaq as unconstitutional, So here also Supreme Court stated na कि women का right violate हो रहा है. When you are saying talaq, 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 it's done. So here right of women is getting violated. There is a discrimination based on Article 14. You can say also 19 because it talks about freedom. Then Article 21 which talks about right to life. So all these rights are getting violated. And when the Supreme Court declared it to be unconstitutional, that means not a valid mode of giving talaq, this was accepted by everybody. In fact, in order to give more strength to the judgment of Supreme Court, because still in certain part of India people were following it, government came up with the law where it made it as a criminal offence and non-bailable offence, that if you pronounce talaq through the mode of triple talaq, you can be held liable. So this is how it works in a common law jurisdiction. Binding precedent for all subordinate courts in the hierarchy. So if Supreme Court has passed a judgment, that would be binding on High Court, that would be binding on Session Court, that would be binding on District Court. So every court is bound by the judgment of the court which is above in hierarchy. And also, for example, every judgment works as a precedent. When we talk about Keshwanand Bharti judgment, so it is one of the, you can say, best precedent which we have created and which defines the basic structure of the constitution. So here it is binding on everyone that okay, fundamental right is the basic structure of the constitution. In no scenario this can be taken away. You can amend fundamental right, but you cannot take away the crux behind fundamental right, why it has been added in constitution. In no case, no circumstances आप उसको हटा सकते हो. So this is what is the role of a judgment which plays as a precedent. Then obviously when we are talking about common law system, we also need to understand the aspect of civil law system. So it is followed in countries such as Germany, Russia and continental Europe. Under common law, judiciary can make laws through judicial decision of court. This is just we discussed in the last slide. But under civil law, only the legislature or executive has the power to create laws and rules. That means here role of judiciary is not that relevant in making laws. They can decide the case, but they can't make laws. So in common law, in civil law, it's very much specific to legislature and executive, which is not there in common law. In common law, judiciary is also having a important role, because when we talk about the top three organ of the government, so it's legislature, it's executive and it's judiciary. So everybody shall be given importance, everybody shall be treated on equal footing, which is there in the common law system. So this is the first salient feature of Indian judiciary. Okay, when we talk about the second salient feature of Indian judiciary, it's the adversarial model of dispute resolution. Now, when we talk about adversarial model of dispute resolution, here the role of lawyer becomes very important. He will play a vital role in, in deciding the case, because he is the one who is representing your case. He is the one who is presenting the fact before the court of law, and basing on the fact and evidences produced by your lawyer, the opposition party's lawyer, the judge comes to a conclusion. So for example, suppose there's a dispute between A and B are brothers and they have some property dispute. A hired C as a lawyer, B hired D as a lawyer. So when the matter goes to court, there will be a judge E who is neutral, who is neither known to party A and C, who is neither known to B and D, and basing on the facts, evidences which is produced before the court, they'll decide the case. So here judge is a very neutral person. He cannot be a biased one. But when we talk about, say, biasness cannot be there in inquisitorial also, but here the role of judge is not that straight, or you can say they don't get involved in the process of selecting the facts. They don't get involved in the process of finding out the evidences or how the proving is being done, how is police working. They don't get involved in all these things unless and until you bring a fact to the court. But in case of inquisitorial system of law, judges are more proactive. That means they take part in the process of selection of evidences. They take part in the process of, prove also, like how does a police inquire about a murder. So similarly, maybe judge can also go and check that acha ye murder hua hai, ye weapon hai, okay, कहाँ पे है, मतलब they can go into the process of selecting evidences and all. So this is what is difference between adversarial and inquisitorial. Here it's the role of judge is more proactive, which is not there. Here the role of lawyer is very important, and we follow the adversarial model of jurisdiction and not the inquisitorial model of jurisdiction or dispute resolution. Okay, then the next important thing is we have read about, you know, Supreme Court, we read about High Court and the lower judiciary, and also we discussed about the salient feature of Indian judiciary. Then the next topic which is mentioned in your legal studies book is Attorney General of India and law officers. So at, you know, in central level, at state level, you do appoint certain law officers who works for you. And that position can be through constitution, that position can be through different statutory laws also, or for that matter state laws also. So law officer at a union and state level exists to advise the executive wing of the government. So for example, again same मैं sedition वाला example लूँगी. So here sedition में Supreme Court तो एक तरफ से है, एक party, whenever it's a criminal matter, one of the party always would be state. So when state is coming to Supreme Court, there will be a person ना who would be advising the state or who would be advising the, you know, union government कि आपको कोर्ट में जाके क्या बोलना है या हम कोर्ट में मैटर को कैसे represent करेंगे. So for that purpose you need a law officer, and at central level that law officer is the Attorney General, and he is the first legal officer of the country. He is appointed by the President under Article 76 of the Constitution. So we can also say that the post of Attorney General has been created by Constitution. It's a constitutional post and can hold the office during the pleasure of the President. And he must be, when we talk about Attorney General, so I am a lawyer, I cannot be appointed as Attorney General. There has to have certain qualification. If a person qualifies that, you know, criteria, then only that person can be appointed as Attorney General. So he must be qualified to be appointed as Judge of Supreme Court. So if a person is qualified to be, you know, holding a post of Judge of Supreme Court, then that person can be made as a Attorney General. Now we'll also discuss, you know, after a few slides or maybe in a second video about the appointment of judges of the Supreme Court. Okay, now again it is talking about the, or it is explaining the features of Attorney General. So it is stating it gives advice to the Government of India upon legal matters as explained कि sedition में वो government को reply या advice दे रहे होंगे कि हमें कोर्ट में जाके क्या बोलना है, हमें कोर्ट में ये बोलना है क्या कि हम इसको देखेंगे, ठीक है, will change the law. Obviously it's a colonial era law, अभी के time में applicable नहीं है. So all these advice would be given by the Attorney General. He has a right to appear in court, that is right to audience. He can also represent the government in court. He can go and also hear what's happening in the court. So that is the role of Attorney General. Proceeding of Parliament without a right. So the Attorney General, being a constitutional body, he can also attend the proceeding of Parliament, that is Lok Sabha and Rajya Sabha. He can go, he can attend, he can watch the proceeding, but they don't have a right to vote, because they are not the one who has been elected by people. So obviously, or they have been, you know, appointed to Rajya Sabha, so they don't have a right to vote, but yes, they can participate in the proceeding. They are assisted by a Solicitor General and 4 additional Solicitor General. So यहाँ पे भी hierarchy, Attorney General comes at top, then you have Solicitor General, and then you have 4 additional Solicitor General. So these, I mean, obviously Attorney General cannot handle things on his own, na? So there are people to assist him. So here is the 4 additional Solicitor General, then you have Solicitor General, and at the top, because he is the first legal officer, he is the Attorney General. Then Solicitor General and Additional Solicitor General is not recognized in the Constitution. So they are appointed, the provision of SG and ASG is not mentioned in the Constitution. So they are appointed by the rules which has been made by the Parliament. So as I have already stated, that there can be an appointment through Constitution, or there can be appointment through different laws, different rules. So these positions are governed by the rules which has been enacted by the Parliament. Then constitution, roles and impartiality. So here when we are talking about judiciary, we also need to understand certain features of judiciary and the position or the power which has been given to judiciary under constitution. So one such important article is Article 50 of the constitution, which talks about separation of power, which says that legislature, executive and judiciary are three separate organs of the government. They shall not be interfering in working of each other. They shall work independently. Judiciary जाके law बनाने लगे, legislature जाके judgment देने लगे. So there will be a kind of chaos which we have to avoid. So that's why we have Article 50 of the Indian Constitution, which lays down the rule of independence of judiciary, which clearly state that legislature जाके law नहीं judgment नहीं देगा. That means you are giving the full power to judiciary to give judgment. You are giving the power to judicial review. That means you are trying to maintain the independency of judiciary. You are trying to, or you are stating that the legislature and executive cannot curtail the power of judiciary. Hence Article 50 plays a very important role. We need to have an impartial judiciary. We need to have a judiciary which is not influenced by government. That's why Article 50, which talks about separation of power, is a very important article. Then judiciary autonomous status, separate from the executive or legislature wing of the government. This is what is Article 50 talking about, which is again the same thing, separation of power. Independence. Why we need an independent judiciary? Because this helps in maintenance of rule of law, ensuring good governance and creating a free and fair society. अगर गवर्नमेंट स्टार्ट करती है इंटरफेयर करना जुडिशरी के वर्किंग में, सो मे बी देयर विल बी अ सिचुएशन ना वेयर गवर्नमेंट वुड वांट कि आप मेरे फेवर में जजमेंट दो. So in order to avoid all these things, importance of judiciary is very, plays a very crucial role in a country. Also, whether government is acting arbitrary या फिर country में rule है या नहीं, law है या नहीं, उन सबको देखने के लिए until and unless you go for an independent judiciary, it's not going to happen. So this plays a very important role in any legal system. It monitors and maintains the check and balance over the other arms of the government. Suppose government ने एक law बनाया and that law is violating your fundamental right. So unless and until judiciary is an independent body, वो कैसे check करेगी कि government ने जो law बनाया है whether it's violating your fundamental right or not? And when they'll check, then only they'll come up with a conclusion or they'll come up with the judgment कि आपने जो XYZ law बनाया है ये लोगों के fundamental rights को violate कर रहा है, so we are nullifying it, we are declaring it as unconstitutional. For all these purpose, independence of judiciary plays a very important role. Again, it is talking about judiciary emerges as a mediator when any organ of the government exercises excess power. For instance, the Indian police has extensive power for crime detection. So this is what is being explained over here is, we all know that if a person gets arrested and person को आप पुलिस स्टेशन में ले जाते हो, पहली चीज़ दिमाग में आती है कि पुलिस उसको फोर्स करेगी टू गिव स्टेटमेंट, या पुलिस उसको 3rd डिग्री टॉर्चर देगी कि आप अपना क्राइम एक्सेप्ट करो. जैसे एक बंदा पुलिस के डर से या पुलिस की पिटाई से मार से एक्सेप्ट कर लेता है कि मैंने मर्डर किया है, सो वेदर दैट confession can be used against that person or not. So no, that confession cannot be used against that person because it is perceived that पुलिस ने force किया है, डर के मारे बंदे ने बोल दिया कि मैंने murder किया है. And there's a provision in under constitution also, which is Article 20 clause 3, which talks about self incrimination, which gives such kind of protection कि आप पुलिस के सामने confession देते हो तो वो valid confession नहीं है. But who will look into this कि पुलिस के सामने confession दिया या judicial magistrate first class के सामने confession दिया? So there comes the role of judiciary, and that's why we say that it emerges as a mediator when organ of government exercises excess power. जहाँ पे पुलिस अपना पावर एक्सरसाइज कर रही है, 3rd डिग्री टॉर्चर दे रही है, पिटाई कर रही है, वहाँ पे जुडिशरी विल कम इनटू पिक्चर एंड से दैट व्हाई यू आर डूइंग सो, and if a person has confessed before you, I am not going to accept that confession. It's not a valid confession. So there the role of judiciary is again very important. Then again it is talking about, it ensures that constitutionally guaranteed freedom, that is basically fundamental right. Government rights, fundamental rights आपको कौन देती है? Government देती है. अगर वो गवर्नमेंट आपके फंडामेंटल राइट को वायलेट कर रही है, फॉर एग्जाम्पल आपको फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन है, गवर्नमेंट ने कर्टेल कर दिया, गवर्नमेंट ने बोल दिया आज से आप फेसबुक पे कुछ पोस्ट नहीं करोगे, ट्विटर पे कुछ पोस्ट नहीं करोगे, सो योर फ्रीडम इज गेटिंग कर्टेल्ड बाय द गवर्नमेंट. व्हेन गवर्नमेंट इज पुटिंग सच रिस्ट्रिक्शन, वेदर दैट रिस्ट्रिक्शन इज जस्टिफाइड और नॉट, अगर गवर्नमेंट ने आज मुझे बोल दिया कि मैं फेसबुक पे कुछ पोस्ट नहीं करूंगी, तो वेदर दैट रिस्ट्रिक्शन जो गवर्नमेंट ने मुझ पे इम्पोज किया इज वैलिड और नॉट, हु विल चेक? So we have again the court who will check into the validity of law, who will check that मेरा fundamental right violate नहीं हो रहा है. Obviously government impose कर सकती है restriction in certain cases where my action can be harmful for country, या मेरे action के कारण इंडिया और किसी और country का relationship खराब हो रहा है, या society में chaos हो रहे हैं, या society में कुछ fights हो रही है. So in that case they can obviously put up a restriction on my freedom of speech and expression, but if the restriction is not justified, Supreme Court will come into picture or the court will come into picture. Judiciary act as a guardian of fundamental rights which are constitutionally guaranteed to every citizen. So again, as I have stated initially also, that it act as a guardian, it act as a custodian, it is the protector of law. So there again, role of or importance of judiciary is very important, and independence of judiciary is vital for the respect of due process of law. When we say the term due process of law, it basically means that law should be just, it should be fair, it should be equitable, action of government shall not be arbitrary. Then the different roles of Supreme Court. So here basically we are talking about the jurisdiction of Supreme Court. So obviously when we talk about jurisdiction of Supreme Court, it can be divided as original jurisdiction, it can be divided as appellate jurisdiction, it can be divided as advisory jurisdiction, it can also be divided as writ jurisdiction, which generally forms under the category of original jurisdiction, or for that matter we can also talk about PIL, which is the public interest litigation. So primarily exercises the role of an adjudicator. मतलब Supreme Court का काम क्या है? Dispute है, उसको settle करना है. So that is they basically act as an adjudicator. Then Article 131 of the Constitution, Supreme Court has ओरिजिनल जुरिस्डिक्शन. बहुत सिंपल है इसको समझने के लिए. ओरिजिनल जुरिस्डिक्शन मीन्स कि इफ सेंटर और स्टेट के बीच में डिस्प्यूट है, दो स्टेट के बीच में डिस्प्यूट है, उसको कौन डिसाइड करेगा? सो सुप्रीम कोर्ट इज देयर. देन इट adjudicate dispute amongst between union or state, or for that matter between two or more state. This is what is under original jurisdiction. Then we have Article 32 of the Constitution, which talks about enforcement of fundamental right. So it's an extensive original jurisdiction to Supreme Court for the enforcement of fundamental rights of citizens through issuing directions, orders and writ. So this is what we have discussed, that writ also falls under the category of original jurisdiction. There are 5 types of writ, which is mandamus, habeas corpus, writ of prohibition, certiorari and quo warranto, which we'll discuss in subsequent classes. Then the appellate jurisdiction of Supreme Court can be invoked by certificate guaranteed by the High Court. अगर मैं High Court के judgment से satisfied नहीं हूँ तो मैं अपील में जाऊँगी. मैं अपील में कहाँ जाऊँगी? Supreme Court के पास जाऊँगी. So that is also the appellate jurisdiction. Then it is also having a power under Article 136 of the Constitution, which is known as special leave petition, which is a discretionary power of Supreme Court. यहाँ पे if you move to Supreme Court may accept your petition, may not accept your petition. Under Article 136 of the Constitution, Supreme Court will only decide a matter when law is in question, or the interpretation of law is in question, or constitutional validity of a law is questioned. There Article 136 comes into picture. Then court's advisory jurisdiction may be sought by the president, which is Article 143. So अगर प्रेसिडेंट को कोई एडवाइस चाहिए तो वो सुप्रीम कोर्ट के पास अंडर आर्टिकल 143 में जा सकते हैं. अगेन यहाँ पे सुप्रीम कोर्ट इज नॉट बाउंड टू गिव द एडवाइस. इट्स एन अगेन डिस्क्रिशनरी पावर ऑफ सुप्रीम कोर्ट. और सुप्रीम कोर्ट जो एडवाइस देती है वो भी प्रेसिडेंट पे बाइंडिंग नहीं है. So president may accept the advice or may not accept the advice. So the only thing which we need to keep in mind is the jurisdiction of Supreme Court, which falls under the category of original, appellate, advisory and writ jurisdiction and all, or for that matter SLP also. Then the last one is public interest litigation. So here the basic rule of law is not applicable, that is of locus standi, कि अगर आपका केस है तभी आप कोर्ट में जा सकते हैं. नहीं, अगर आप पब्लिक स्पिरिटेड पर्सन है, अगर आपको सोसाइटी के लिए काम करना है, एंड इफ़ यू फील दैट उस सोसाइटी में कुछ इशू है, लेट्स से म्यूनसिपैलिटी वहाँ पे काम नहीं कर रही है, सोसाइटी में बहुत पोल्यूशन है, आपका हेल्थ अफेक्ट हो रहा है, आपके आसपास के रिवर पोल्यूटेड है, you can go to Supreme Court under PIL. So you can file a PIL on behalf of society, on behalf of state, and where Supreme Court will look into that matter. So it is a part of judicial activism of Supreme Court through public interest litigation, which is also known as Janhit Yachika. First ever PIL is listed as Husaina Ara Khatun versus State of Bihar. इसमें क्या हुआ था, बहुत सारे prisoners जेल में काफ़ी टाइम से रह रहे थे, बहुत इनह्यूमन ट्रीटमेंट्स हो रही थी उनके साथ. सो PIL फाइल किया कि आप इनके कंडीशंस को देखो. सो वहाँ से द कॉन्सेप्ट इवॉल्व, एंड ऑब्वियसली जस्टिस PN भगवती इज द, यू कैन से, पायनियर ऑफ coming up with the concept of PIL in India. So Supreme Court judge, a bench headed by Justice PN Bhagwati, declared the right of free, legal and expeditious trial of these prisoners in case of Husaina Ara Khatun. So he is also considered as father of PIL. So PIL plays a very important role. अगर आपको लगता है कि आपके एरिया में कुछ प्रॉब्लम है, सुप्रीम कोर्ट को उस पर इंटरफेयर करना चाहिए, सुप्रीम कोर्ट को लॉ लेके आना चाहिए, तो यू नीड नॉट हैव अ लोकल स्टैंडर्ड, यू कैन डायरेक्टली गो टू सुप्रीम कोर्ट अंडर PIL. It has encompassed several issues including socio-economic right, freedom from bonded labor, legal right entitlement like right to food, right to work, environmental issues, clean air, water. वो जो दिवाली पे बंद करते हैं क्रैकर्स का यूज़ करना, वो भी तो PIL के थ्रू आया था. And political reforms, disclosure of assets by members of executive, disbursement of natural resources done by the government. So all these are national issues, social issues, economic issue, which has been taken by the court under the category of PIL. Then high courts and lower courts. As we discussed about the Supreme Court, similarly there are provisions for High Court and lower court. High Court is also having original jurisdiction, appellate jurisdiction. So organ of judicial administrator at state level. Supreme Court तो national level पे, state के dispute के लिए we have High Court at state level. Then lower court function as centers of civil and criminal justice at district level. District court are usually courts of first instance. So this we have already discussed that पहले आप district court जाते हो, वहाँ से satisfied नहीं है, then you move to High Court, and वहाँ से if you are not satisfied, then you move to Supreme Court. So we need not to discuss in much detail. Then this is also something which we have discussed, that why we need an independent and impartial judiciary, because here we are talking about the enforcement of rights, and unless and until they are independent, they are impartial, they won't be, looking into our rights. So for that matter, it's very important that the judges, judiciary is very much independent, they are impartial, they are not biased towards a particular parties. Then provision relating to judges. So once appointment, judges are provided with a security of tenure, मतलब उसके पहले आप उनको नहीं हटा सकते हो. 62 is for High Court, age of retirement. 65 is for the Supreme Court judges. They are not allowed to practice as advocate in the same or equivalent course. For example, एक Supreme Court के judge retire करते हैं, उसके बाद वो Supreme Court में practice करने जाएंगे. So maybe this will affect the impartial or independent provision, because वो already judge रह चुके हैं. So वहाँ पे judiciary और judgment impact हो सकती है. So they are not allowed to work. A retired High Court judge can practice in the Supreme Court but is prevented from practicing in the same or other High Court, because again High Court same footing पे आती है सारी. So एक High Court में judge थे, दूसरे High Court में जाएंगे, वहाँ पे again things will get impacted. So they can practice in Supreme Court but not in a High Court. Then judges cannot be easily removed from their office except for the proven misbehavior and incapacity. The salaries and allowance of judges are fixed and not subject to vote of legislature. मतलब ये fix है only in certain circumstances. Let's say if there's a financial crisis or financial emergency, उसको आप reduce कर सकते हो. The conduct of judges of both Supreme Court and High Court cannot be discussed in Parliament or state legislature except when a motion for removal. Unless and until आप impeachment process start कर रहे हो, unless and until आप removal process की बात कर रहे हो, you cannot remove a judge, or you cannot discuss the conduct of judge also. Supreme Court of India has been authorized to have its own establishment and to have a complete control over it. Means government cannot interfere in the working of judiciary. So in this lesson we have discussed about Supreme Court, High Court and Lower Court, unki hierarchy kya hai, who is having what power and how they deal with a particular matter. Then we have also discussed about the legal officers which is appointed through constitution and other rules which is made by the government. We also discussed about PIL and independence of judiciary. So we'll continue in next class. Thank you.